Good afternoon, everyone. Before I start, I would like to introduce myself. I'm Dr. Sofia Galani. I'm a law lecturer at the University of Bristol in the UK, where I also completed my PhD on terrorist and pirate hostage taking and the protection of the human rights of hostages. What I'm going to present today is a paper on the protection of the right to life in the European Court of Human Rights. And I would like to examine how the European Court of Human Rights has used the margin of appreciation when it comes to the protection of the right to life in the context of anti-terrorist operations. And as you see from my title, I asked whether desperate times call for desperate solutions. I would like to start my presentation with something that Hippocrates used to say, that for extreme diseases, extreme methods of cure as restriction are most suitable. And the reason I say that is because of what we see in the context of terrorism and anti-terrorist operations, especially when it comes to hostage taking. A hostage taking might last for days. It attracts lots of media attention, and that makes states and governments feel very, very uncomfortable. So usually they want to get this done as soon as possible. They want to end hostage taking as soon as possible. And this sometimes means that they might adopt very extreme measures to respond to a hostage taking. And this will have a significant impact on the victims. And what I have found fascinating, but also very challenging in my research, is that when it comes to this debate about terrorism and counter-terrorism and human rights, it has all been about the protection of the human rights of terrorist suspects. And there is lots of literature on this, and there have been lots of cases, and there have been judges and policymakers and special reporters on counter-terrorism, and they all call states to ensure that when they fight terrorism, they protect and they respect the human rights of terrorist suspects. And I fully subscribe to this view. I think that it's extremely important that when we fight terrorism, we don't lose sight of the human rights elements. But at the same time, I think that it's extremely important to also consider the protection of the human rights of the victims of terrorism and the impact that counter-terrorism measures and anti-terrorist operations might have on the victims. So as I said, the purpose of this presentation of my paper was to examine how the European Court of Human Rights has interpreted the substantive and procedural obligations of states under Article 2 in the context of anti-terrorist operations. In order to do that, I'm going to discuss some of the European Court of Human Rights case law, and more specifically, I'm going to focus on the cases of Finogenov against Russia and Tagayeva against Russia. And what I, with this case law, will show is that the court, in my view at least, has taken significant steps towards reinforcing the obligations that states have in the context of anti-terrorist operations. However, the court has become more and more aware of the national security challenges that the state faces when it responds to terrorism. And what we see now is that the court has started using the margin of appreciation when it comes to examine the right to life. And the problem there is that, one, under Article 2, the state was not really supposed to use the margin of appreciation. And secondly, the way that the court has used the margin of appreciation has created lots of inconsistencies and has led to a lack of clarity that is not compatible with the nature of the right to life. Before I start discussing the most substantive issues, I would like to give the facts of the two cases that I'm going to discuss in order to make sure that we all know what we're talking about. The first case is the case of Finogenov against Russia. So back in 2002, a group of armed Chechens stormed the Moscow theater, and they took 850 people hostages. The Russian response was no negotiations, but after 3 days they decided to use a poison in order to render terrorists unconscious before they stormed the theater. Now, the problem there was that the formula of the poison was not disclosed to the public, but it was not even disclosed to the medical staff and the emergency services. So once they managed somehow to transfer all the hostages to the hospitals, some of them died because the medical staff didn't really know how to treat the hostages.
And what about the hostages?
Sorry?
Some of the hostages.
Yeah,
They
the
died.
hostage.
Oh, the hostages. Sorry, yeah.
So yes, because as I said, because they didn't know, the medical staff didn't know how to treat the hostages, some of them died. Some of the hostages died, as you see from the photos, while they were being transferred to the hospitals because Russia did not really have an emergency plan in place or medical services in place, so they started piling the hostages outside in a very cold weather. Some of them choked and they died there. Some of them died in the buses because they were using public buses to transfer the hostages to the hospitals. So after the hostage-taking incident, the Russia conducted some investigations. They found no failings on behalf of the Russian forces, on behalf of the Russian agents, or on behalf of the medical staff, and there were no prosecutions. The case was examined by the European Court of Human Rights. The applicants argued that there was a failure on behalf of Russia to prevent the attack, but the court said no. They said that Russia here did not have enough information to know that there would be an attack, so there was no failure of Article 2 in that respect. There was a violation of Article 2 in relation to the poor planning and control of the operation. The court did not find a problem with the use of the poison because they said that although it could be seen as lethal force, it wasn't immediately lethal, and if the Russian authorities had in place the right medical support, hostages could have survived. But there was a problem because there was no evacuation plan or medical assistance in place, and that was a violation of Article 2. And the court also found a violation of the procedural obligations of Russia because the investigations were not independent and were not effective. Now, 2 years later, we have the Beslan school attack. So again, we have armed Chechens storming the biggest school in the Beslan area. The first day of the school year, which in Russia is a big celebration where all the students go to the school with their parents and their siblings to celebrate the beginning of the year. It's the Day of Knowledge. Chechens stormed the school. They took 1,100 hostages, 800 of whom were children. Some of them were like babies, 2-3-month-old babies, and up to 18-year-old kids. Again, here Russia did have some information, but they did not protect the school on that day. There was only one police officer at the school, and she was unarmed. There were Chechens tried to negotiate. The Russians refused to negotiate. There was no effort to have any sort of dialogue or channel communication. And again, 3 days later, again, they decided to storm the school. A very controversial rescue operation. They used flamethrowers and tanks and everything that you can imagine. So basically what happened was that the ceiling of the school caught fire and it fell on the victims that were being held in the gymnasium, and again, most of them died. 300 of the victims were burned to an extent that their bodies could not even be identified. And again, after the operation, there were numerous investigations. Again, Russia said we did nothing wrong, we did everything we could to deal with the attack. So there were no failings on behalf of the Russian authorities, and there were no prosecutions. Now, what did the court say? The case was only released in April 2017. I have to say that this is not a ground chamber case, that it is now final, because Russia did not appeal the case. So the case has now become final, And the case was also included in the court's reports, which means that it's one of the landmark decisions that will be used in the future to guide our understanding and interpretation of Article 2 in this context. So it is a very important case. Now, the court said for the first time that a state failed breached Article 2 because they failed to take reasonable measures to prevent the attack. So in this case, the court took a completely different approach from the approach the court took in the case of Finogionov. And they said that hostage taking has become all too common. Russia had enough intelligence information. They should have known about the attack. They failed to take reasonable measures to prevent the attack. The court also found a violation in relation to the planning and conduct of the operation, and again said that they failed to communicate with each other properly. They failed to have a plan. They failed to have a channel of communication. They used excessive lethal force. So basically, the rescue operation again was a huge disaster and violation of Article 2. And they also found a violation of Article 2 with reference to the procedural obligations of Russia. And again, the court said that the investigations were not effective. They were not available to the public. They were not open to the public and the victims. So the investigations were not effective, and that was a violation of Article 2. So what does this say? I mean, these two cases, in conjunction with other cases decided by the European Court of Human Rights, basically tell us that the court has now established some very clear-cut obligations that the states have when they respond to terrorism and when states conduct anti-terrorist operations. So before an attack, a state has an obligation to take reasonable measures to prevent a terrorist attack or minimize the losses of life of such an attack. During an attack, the state is obliged to try to put an end to the attack, and they have to do that by planning an operation carefully in advance, by controlling an operation carefully. They have to use force, but only as a last resort and only to save lives. And they have to take precautions to minimize incidental loss of life. That means that they have to make sure that hostages, for example, will not be killed by the fire of the hostage takers. And they also have an obligation to have evacuation plans and medical assistance in place. And after the attack, the state is under an obligation to conduct an effective and independent investigation. And if appropriate, a state will also have to punish those responsible. Now, the approach of the court is not surprising for the reason that the nature of the right to life is very important, and the court has also said that in its own jurisprudence. So there is an agreement that the right to life ranks as one of the most important provisions. If we don't have the right to life, we can't enjoy any other rights. And the court has also said that in the case of McCann, where it said that the right to life is one of the most fundamental provisions. The drafters of the convention, Article 2, also recognizes the importance of the right to life. The right to life is not, strictly speaking, an absolute right. So in some cases, deprivation of life is allowed, but it's allowed only when it complies with Article 2, Paragraph 2, so in defense of any person from unlawful violence in order to effect a lawful arrest or prevent the escape of a person, an action lawfully taken for the purpose of quelling a riot or insurrection. And as the article says, that the use of force must be no more than absolutely necessary for the purposes of ABC, Article 2, Paragraph 2. And the absolute necessity test was also discussed in the case of McCann, where again the court said that deprivation of life is allowed, the use of force will be lawful when it is absolutely necessary to achieve one of these objects outlined in Article 2, Paragraph 2. Now, what is the problem that we have now with the court? The problem that we have now with the court is that the court has started gradually using the margin of appreciation when it examines the right to life in Article 2. And the margin of appreciation is long embedded in the jurisprudence of the court. The court has used the margin of appreciation extensively when it comes to Articles 8 to 11. And in this case, we might have conflict of rights, or we might have to deal with controversial issues where there is no consensus. And in these cases, the court has either tried to balance the rights using the proportionality test, or they have said that because there is no consensus on the matter, we're going to give the states a margin of appreciation, and they can decide themselves how they're going to interfere with the rights and how. In relation to Article 2, the court has used the margin of appreciation in relation to the question of when life starts and when life ends. So, in the case of Vaux against France, where a woman was pregnant and the doctor there by mistake terminated her pregnancy, she argued that the embryo had the right to life, and the court said that there is no consensus on the matter. So, there was no violation of Article 2 there in relation to the right to life of the embryo.
Why is that margin of appreciation?
It's not a margin of appreciation, but to come to the court said it was.
Okay.
I'll speak to the court said it was. They were wrong.
They have, in a sense, deferred when they examined the case of Paul against the UK and to the question of assisted suicide, and that had to do with whether the right to life entails the right to death. And the court said no, and again, basically, the court there allowed states to choose whether they want to legalize assisted suicide or not. Now, the court had not used the margin of appreciation in relation to the use of force and when use of force is allowed and how states should use force under Article 2, but this is something I'm going to examine in a minute. And finally, what we see a lot lately is this security debate and the security rhetoric, where basically there is a debate of whether we should balance or how we should balance national security with human security, and yes, how we do that. And again, we'll come back to this point in a minute. So now, as I said, the court has started using the margin of appreciation when it comes to the examination of the right to life in anti-terrorism operations. But what we're going to see now, going through the different obligations in the different cases, is that the court has used the margin of appreciation very inconsistently when it comes to the different obligations. The obligation to prevent an attack, the obligation to control an operation and use lethal force as a last resort, etc., and the obligation to investigate and prosecute. So the court has used inconsistently the margin of appreciation in relation to these three obligations under Article 2. But the court has used the margin of appreciation inconsistently within the same cases, and across different cases. In relation to the obligation to prevent, this is the least difficult to examine. The court, when it examined the Russian responses in the case of Tagayeva, they said that there was a violation of Article 2 on behalf of Russia because they failed to take reasonable measures to prevent the attack. The court there actually gave consideration to the intelligence information that the Russian security services had, and the court said that the information that the Russian authorities had was clear in relation to the geographical location of the attack, the nature of the attack, and the imminence of the attack. In other words, the court said that Russia here knew that there would be an attack in the region against civilians and educational facilities. There was lots of increased activity around the school and in the region before the attack, so you could have taken some measures to prevent the attack. No margin of appreciation, no reference to margin of appreciation, which personally I find very surprising for the reason that when it comes to examining intelligence and security information, I would not have been surprised if the court said I cannot examine intelligence information and I cannot tell the states how to use intelligence. but the court was very clear that they knew enough and they should have done more to prevent the attack. But as I said, this is the first case in which the court found a violation on behalf of the state to prevent a terrorist attack. So we don't really know how the court will deal with this question in the future, and whether the court will be as strict as it is now, or whether it's going to change its approach. Now, when it comes to the planning and control of an operation, the use of force, the court has been much more inconsistent. So in the case of Macan that I mentioned earlier, the court was very clear that the use of force must be no more than absolutely necessary, which is what Article 2 says. And the court in that case distinguished between other articles, Articles 8 to 11, and they said that we have to treat the absolute necessity test in a very different way from the other articles in which some margin of appreciation, the test of proportionality, might be used. This consistent approach lasted for almost 20 years, if not more. And then the court, in the case of Noganov, they said that actually states should enjoy marginal appreciation when it comes to military and technical aspects of the situation of a military operation or a terrorist attack. So yes, as I said, a big U-turn there on behalf of the court. The court justified the marginal appreciation on the basis of the rarity of the attack, of the exceptional circumstances of the attack, on the large scale of the attack, and they said that because of all of these issues, states should be granted marginal appreciation. Now, in the case of Tagayeva, the court made no reference to marginal appreciation, and this is not surprising for the reason that they justified the marginal appreciation on the basis of rarity and exceptionalism. But the court soon realized that these large-scale terrorist attacks and large-scale terrorist operations are not that rare anymore. And the case was decided in 2017 after a number of attacks on European soil. So the court realized that they have to actually examine these issues, and we cannot just defer saying that there is a marginal appreciation. This is not to say that the court did not really have the marginal appreciation in mind, because what the court said here is that although they didn't explicitly say that the states have a marginal appreciation, is that actually states should have some freedom when they choose the means and methods of responding to a terrorist attack. So the court here said the states do have to protect the rights to life. There are positive human rights obligations here, but we're going to allow states to choose the means and methods of protecting these rights and safeguarding the right to life. But as I said, across the cases, when it comes to the use of force, the court sometimes might be very strict, sometimes might be less strict, and we don't really know how it's going to be in the future. Now, when it comes to the obligation of states to investigate a terrorist attack and an anti-terrorist operation in response to this attack, again, the court uses the marginal appreciation and does not use the marginal appreciation. So when it comes to the effective, to the criteria that the court uses to examine how effective and independent an investigation is, the court is very strict. And it has said that the investigation, this obligation is an obligation of means, not of result, which means that the states do not really have to find out exactly what happened, but they have to take all reasonable steps that they have available to try to establish the truth and how force was used and how victims died, etc., etc. So it has been very strict, and there are other cases here that do not have to do with terrorism, such as the Zalud case, and which had to do with an operation of the Dutch government in Iraq, and there the Netherlands was found being breach of their procedural obligations because they didn't have a post-mortem examination, which basically, as the dissenting opinion said, it was very difficult for the Dutch authorities to have in this context. But as I said, the court has been consistently very strict. And I have the case of Armani da Silva on the slides, but the court was very strict with Russia, both in the case of Tagayeva and Finogyanov. And the case of Tagayeva, for example, we had large numbers of victims. Russia did not even have enough morgues to keep the victims, so they were able to conduct post-mortem examinations and establish how the victims died. But the court did not give them any leeway. They said that you should have done the post-mortem examinations even after the bodies were buried. You should have done everything you could to establish the truth. Now, when it comes to prosecution, the state is not that strict, and this links very well to what we were discussing with Kaluk yesterday. But the idea is that if an agent honestly and genuinely believes that the use of force is necessary, then the court will not hold the agent responsible. And if a state decides that the agent should not be prosecuted, then again the state there will have some margin of appreciation. And again, this has to do with the threshold evidential test and whether the state thinks that the prosecution is necessary, it's good for the public, it's cost-effective, etc., etc. So, where do we stand now? What have we seen? What we saw basically is that the case of Noginov Martin a necessary departure from the case of Martin. We had for many years we had the absolute necessity test in line with Article 2, in line with Article 2, Paragraph 2, and the court had been quite consistent. And then in the case of Noginov, they explicitly said that states should have a margin of appreciation. They have tried to use the margin of appreciation on the basis of the rarity of the attacks, on the basis of the exceptionalism of the attacks, on the basis of the factual circumstances. But this basically means now that the court might decide how the right to life can be restricted and how use of force might be used on the basis of the factual circumstances, which in my view is wrong, because when it comes to the right to life, there should be some strict criteria and a clear test about when the right to life can be restricted and when it cannot. And as I said, the problem comes here because the court has been very inconsistent, and they use the margin of appreciation in some cases, they don't use it in some other cases. It's not entirely clear why we need it in some cases and why we don't need it in other cases. The court can use, is more willing to use the margin of appreciation when it comes to the use of force, because it's actually during the operation. But the court feels that things are very controversial and very difficult for a state to handle, so states should have some margin of appreciation in the way they respond to an attack. And they're more strict when it comes to preventive obligations and the investigative obligations. And what I say is that the court there uses these obligations as a safety net, as I say in my paper. So we're very strict when it comes to prevention. We don't want the violation to take place. We don't want the right to life to be affected in any way. So we're very strict when it comes to prevention. We're very strict when it comes to the investigation, because we will have to rectify the problem there by investigations that will lead to compensation. But when it comes to the use of force, we're a bit more relaxed because of the problems and the challenges that a state faces. But again, I think that it's during the operation and when the use of force, when the force is used, that the court actually should remain competent to examine the responses, because this is exactly the time that the right to life will be affected, directly affected by the responses of the state. So yes, I mean, I wrote a different paper on the case of the Gayeva, and I was really enthusiastic about the approach of the court there, because the court I feel that it did very well in terms of reinforcing the obligations that states have in the context of terrorism. And that was a step forward. But then you see that the court has started really struggling when it comes to national security issues and terrorism challenges, and is very aware of the difficulties that states face. And if you read the cases, you will see how many times the court said that we're being aware of the problem, we're being aware of the conflict between Russia and Syria, we're being fully aware about the attacks against the UK, So they keep saying that. But yes, now we're left without any clear criteria about how to protect the right to life. And the other thing that we have here is, as I said, this new security debate that keeps blurring things. And my idea is that we should really stay away from the security debate and the securitization of human rights and the security agenda and all of these issues for two reasons. Because human security is a concept that has not been defined. There is no great definition. And my argument is that if we have to understand human security somehow, we will have to understand it as part of the right to life. And anything that has to do with security will have to be defined and measured with reference to individual protection of individuals. And national security is also something that has not been defined. And the court keeps referring to national security, and there's lots of debate on national security. But the court itself has not clearly said what national security is. And again, I think the only one who could start helping us understand this concept is the states, because if states claim that they have to restrict rights for the purpose of national security, they should tell us a bit more what the problem with national security is there. So should we protect national security? Should we protect human security? Should we find a way to balance this? Should we give some marginal appreciation to the states? Again, I think that it's too late to say that states will not have any leeway when it comes to the way they respond to terrorist operations, and the court has already started giving leeway to states. So I don't think that there's any way of going back and saying that when it comes to terrorist operations, states will not enjoy any freedom in choosing the way they respond to the terrorist operations. And this is why my suggestion is that if we have to give some leeway to states, that should be on the basis of choice of means, which is a type of the marginal appreciation. And that means that states choose the means in protecting a specific right. Okay, but in order for us to be able to let states choose the right means to achieve a specific aim and protect a specific right, that means that we need an agreed outcome. And again, when it comes to human security, national security debate, the only way to have an agreed outcome there and agreed aim to achieve will be to protect the right to life, and as I said, to include human security in the right to life. So yeah, that's it.
Thank you very much. I really appreciate it. I'm going to respond to Sofia's paper more than to the presentation. But I want to begin with something that is half personal. Some of you may know that I was a member of the Human Rights Committee for 8 years. And the first session that I joined the committee, Rosalind Higgins, when it became a judge and the president of the International Court of Justice, was a member of the committee. And she was then elected to be a judge of the International Court. And she was about to leave the committee, and she gave a little speech. And she'd been for 10 years on the committee. And she said, what contribution did I make to the committee? And she said, the one thing that I did was to avoid any reference to, what did she say, I don't think she said despicable, but to the ridiculous margin of appreciation. And it is quite true that if you look at the jurisprudence of the Human Rights Committee, you will, I think, see only one case a long time ago where they actually mention the words margin of appreciation. They've avoided it like the plague. But that does not mean, and it cannot mean, that they don't show deference to the decision-making of national bodies. Now, what I want to do in the time that I have is, as I've said, I think your analysis of the cases is wonderful. And I learned a lot, and it forced me to go back and to read the articles on the margin of appreciation. But to be quite honest, I take total issue with you on the very meaning and the place of the margin of appreciation in these cases and in the jurisprudence of the court. Now, that doesn't mean to say that the court sometimes hasn't used the term, and it did, in fact, implement the doctrine, and at other times it mentioned margins of appreciation, and it had nothing to do with margin of appreciation. So let's see where I go from there. Let's see a very early definition of the margin of appreciation. Oh, sorry, Can you give that to me? Okay, this is one of the first articles written in the 1970s about the margin of appreciation, and we'll see where it came from. The breadth of deference the Strasbourg organs will show to national legislative, executive, judicial bodies before they will disallow a national derogation from the convention, or before they will find a restriction of a substantive convention right incompatible with the state's obligations under the convention. We are talking about two things, and this was the origin of the margin of appreciation. The first was that under the European Convention, Article 15, when can a state declare a state of emergency? If there is a situation that threatens the life of the nation. Threatens the life of the nation, the court said, well, we are not going to be able to decide some objective test of whether the situation threatens the life of the nation. We are going to allow a margin of appreciation for states to decide. That's not saying they can decide what they like, when they like. They have a certain framework within which they can act. So that Switzerland may reach a different decision in similar circumstances to the decision reached by the United Kingdom. Note, at the time, the only countries which were members of the convention were the Western democratic countries. So the court was not really taking a big problem here that they were going to have a big difference between the United Kingdom and between Norway. The issue changed, and that is the problem. The issue changed after they widened, and countries like Russia, which have nothing to do with human rights and should never have been there in the first place, then they joined the convention, and then you have a problem. So that was the first thing. The second, and that is the important thing, is that we have articles 8 to 11, which allow a state to place restrictions on liberty when necessary in a democratic society. And the court said that we are not going to have one view of what is necessary and impose it on all states. We are going to allow a margin of appreciation for a state to decide whether or not it is necessary. That was the original notion of the margin of appreciation. So now I'm going to suggest to you, Sophia, that one distinguishes between a number of issues. And in your article, the whole time you refer to the question of the interpretation of Article 2. And I'm going to put it to you that there's a great difference between the question of interpretation and other questions which arise, which are not questions of interpretation. So let me see what I'm talking about. I don't think, can you read that? It's a bit small. Let's try to see. If I make it larger, will it get larger there? No. Okay. So what is interpretation? Well, you have to interpret the actual terms and language of the convention. What does it mean? What is torture? It's not defined in the convention. What is inhuman treatment? Big problem. How do you define it? What does the right to marriage include? Big question now in the European Court. Does it include the right to marriage of same-sex couples? That's one question. In fact, the question of when does the right to life begin, that's a question of interpretation. And so I will come to the total misunderstanding of that in the Volk case. That is one question, interpretation. The second question is questions which, under the terms of the convention themselves, they require an evaluation or an assessment. The actual convention says that you've got to assess. When you say that something threatens the life of the nation, it demands that you actually assess the situation and see whether that situation threatens the life of the nation. When you have to decide whether something is necessary, you have to decide an assessment. Is it necessary or not necessary? It's not something that you can do by interpretation. It's an assessment, an evaluation of the actual situation. Article 2 mentions that exactly. It says as absolutely necessary, but that's only for deprivation of life. But there are other issues that can arise under Article 2. As we know, under the European Convention, you have the duty to ensure, which is not only to respect the life by not depriving persons of their life, but to take actual actions to protect my right to life. And when that comes in, you can't use the absolute necessity. It becomes absolutely meaningless. You can't say to a state, well, you've got to take all measures that are absolutely necessary or that are not absolutely necessary. No state can do such a thing, and that is a problem. So that's the second question. In other words, the second question, and that is where the original margin of appreciation came in, where the convention itself requires an evaluation or an assessment. And that's when the court says, we are not going to have one objective assessment of the court and impose it on all states. We're going to say that if you're acting within a reasonable framework, we are going to show deference. We're going to allow you a margin of appreciation, not an appreciation, a margin of appreciation. Then you have other questions. And they look similar to the margin of appreciation, and writers themselves and the court itself have sometimes mixed them up. There are other issues which states have to decide on. For instance, the means and methods of implementation. The convention doesn't say what I have to do to implement certain things. Well, the state has to decide it. And they're going to be very different. You're going to have a fair trial. One state is going to have a jury trial, another state is going to have a different thing. This is a means that the state is going to have. Questions of policy in fulfilling positive obligations to protect. This is also one of an issue which is a political issue, which democratic and reasonable states can disagree on what measures we're going to take to protect the public from certain issues. For instance, from crime, or from disease, or from accidents. One country will decide that they're going to impose a duty on everybody to wear helmets in order to protect the life of people. Another state will decide they're not going to do that. They're just going to say you have to have insurance, whatever happens. And then you have the action in concrete circumstances. And this is the big problem of these cases. It's very easy to compare the two Russian cases, but they're totally different. They look the same because they're hostages, but they're totally different because in the one case, the Russians had clear information that there was about to be attack on a certain day in a certain area. In the other case, they had it was the whole of Moscow. What would they do? What would they were supposed to do if they would have told them, you know what, the Chechens are about to attack? They couldn't protect every installation of the public in Moscow. Or it's not only in Moscow, it's in Petersburg, in every single country. So the court obviously had to distinguish between the two cases in what they were required to do in order to protect, given the knowledge that they had. Okay, so these are the kind of questions that you have. And then you have the question, and this is a very, very big question which comes up here. And I've dealt with it a lot, as some of the colleagues here know, not in the context of human rights, but in the context of international humanitarian law and a similar kind of question. You've tried to place the whole thing in the issue of national security versus the right to life. It is true that in the one case, they argued, well, the Russians said that they were going to storm the building because they wanted to save their national honor. Or the national security, but the court said, no, they really actually did it because they wanted to save the life of the hostages and it was urgent. If they would have decided on the general view of national security or national honor, the court would have said, no, that's not a legitimate consideration. Your big problem is as follows. When are you allowed to endanger the lives of certain, even defined individuals in order to protect the lives of others who may be unknown? That's the kind of decision that decision makers make when they go to war, a war of self-defense. They know that some of their soldiers are going to be killed. It's absolutely definite. They're endangering their life totally, utterly. And yet why are they doing it? They're doing it on the basis of the argument that this has to be done in order to try to save the lives of many more people, soldiers and civilians and whoever they happen to be. Now, who can make such a decision? The court can't make such a decision. It's not capable of making such a decision. Those are the kind of decisions which decision makers have to make. And it's not a matter of national security. You could say that when I go to war, it's a matter of national security, but really it's a matter, if you're acting in self-defense, it's a matter of protecting the right to life. Now, you've got a bit of a contradiction in what you've written in your paper. Because on the one hand, you're telling the state that you've got to act to stop me against terrorism. So that is an action based on my right to life. On the other hand, you say that when I'm acting against terrorists who actually threaten the right to life, suddenly it's no longer protecting the right to life. Suddenly it becomes protecting national security. It's a jump there. So now let me see where I differ with you with the view that I even view the whole of the it's impossible to read, I'm sorry. If I make the font larger, will it change?
No,
You
because it's
don't.
on that computer.
Go
not on
sort
this
it out. Sort it out.
It's on that computer, not on this one.
So can you make it larger? I'm sorry I'm being a bit long, but you gave me a challenge and I'm really
I'm gonna
excited
try.
about that.
Continue, I'm gonna try to.
This is gonna be an article.
It's gonna be an article.
Yeah,
Okay,
you're right.
yeah, okay, I'll together with you.
I'll invite you to Prague.
So let me go into it. I read all the articles on the margin of appreciation. And I can accept that you're borrowing a lot of what, not borrowing, you quote a lot of the articles and you quote what they've said. But let me take just one example of how the margin of appreciation has been misunderstood by the court itself. And you cite uncritically two cases, the Vo case and the Kretzmer case. Okay, the one case of endangering a fetus and the other case of the right to end life. And I've always taught the Vo case to my students, and I ask them, is this really a case of margin of appreciation? It's got nothing to do with it. Because you can't have a margin of appreciation in definition of the right to life. What the court was saying in the Vo case was that under the convention, you do not have a duty to protect the life except from the moment of birth. However, and this is a general principle in human rights, if a state wants to do more, it can do so. But under the convention, it's not required to do so. There's no other way you can understand the Vo case. Not a margin of appreciation. A margin that regard assessment, and the margin of appreciation is not something to do with the difference between states. That's always going to exist. The margin of appreciation is only when there's some kind of assessment or evaluation. And so the Vo case was fundamentally, the court was saying, if you look at it and you apply it, the court was saying, under the convention itself, your duty to protect life is from the moment of birth. States are free, if they want to do so, to protect life to a certain extent, not to a full extent, because they have restrictions on the right to stop abortions from an earlier state, from the state of conception, from the state of the viability of the fetus, whatever it happens to be. That your duty under the convention is only from the matter of birth. That's the Vo case. The Plessy case is a different case. The Plessy case was the argument of Mrs. Plessy that the right to life includes my right to end my life. And the court said, no, the right to life under the convention does not include your right to end your life. However, if a state wants to make laws allowing in certain conditions, as they decided later that somebody can end their life in certain conditions, they're allowed to do that. But it's not part of the right, it's not demanded by the right to life. So now let me see where I disagree with you on the very structure of the convention. First of all, not everything is a matter of interpretation, that I've already said. And there was a very big difference between rules and standards. A rule is something which can be applied by any court. They just have to read the facts and they can. Standard involves, by its very nature, something much more amorphous. Hart wrote about this originally. It's mentioned in part of the literature, standards and principles as opposed to rules. Now, if you want the idea of no force, then the force that is absolutely necessary, that's not a rule, that's a standard which has to be applied in specific circumstances. And there are going to be very great differences in the circumstances of whether I think that they've applied to that standard or not. Then you have a matter that demands evaluation or assessment. That's not a matter of interpretation. It's not a matter of interpreting the thing, it's a matter of deciding in the circumstances whether this is necessary or not, which is a matter of evaluation. And then you have the notion of positive obligations, which by their very nature must leave room for discretion. Respecting the right to life and protecting the right to life are not the same thing. And remember that Article 2, which talks about the deprivation of the right to life. It even says intentionally. It's true, the court that says it doesn't only apply to intentional, but it's an actual positive act which deprives a person of their life. Then you have absolute necessity. It's not applicable when you're talking about positive obligations to take acts to protect the population. And then you have the big problem. And this every court has to do. How do you apply standards in concrete circumstances? And no concrete circumstance is going to be alike. And that's what you saw in the two Russian cases that you spoke about now. The concrete circumstances were different. They were different in the way that in the Bestland case, they had prior warning that there was about to be an attack in a specific area on a specific day. They could have got organized. They didn't get organized. In the Moscow theater case, they didn't have warning. If they had warning, it was such an amorphous nature that it was not going to help them. So they couldn't plan the actual response to the attack. But what they could plan, and that was the court said that in any emergency situation, you do have to have planning for what kind of a response you're going to have. And if you're going to use poison, you should have been able to, in the situation, to be planning in advance how you're going to cope with the effect on the poison on the victim. So that's one thing. Now, I said the meaning of the margin of appreciation. There's been much confusion. And I would suggest, first of all, that you do not uncritically refer to the vow and players seek decisions as players, and things are good examples of the margin of appreciation. As I said, I submit that had nothing to do with the margin of appreciation, although in the vow case, the court itself mentioned the margin of appreciation. It didn't do so in the blessing case. But I quoted the original view of the margin of appreciation, but it's progressed from there. And if you look at the literature now says, well, we're talking about every case where they're going to show deference to the states. And that becomes the actual, but that is one question. When I show deference to the way the state applies standards or decides on what means to implement it, very different from the difference between legal systems. You mentioned the whole question of the evidential thing. What is the evidential kind of burden on the prosecution before it decides to prosecute? And the court said there's a difference between legal systems. Quite correctly, we're not going to impose one standard on everybody. In the British system, there has to be a good chance of conviction. Why? Because we have a jury system, and with the judge is going to lose control, and so we're not going to put it to the jury unless the prosecution itself says that there's a good chance of conviction or strong chance of conviction. In others, there's enough evidence for conviction to be possible. Well, okay. The court says we're not going to, look, that's not a margin of appreciation. That's the difference between legal systems, which are both fine. So now we come to the distinction. The next thing that I want to say is the distinction between what judges say and what judges do. And judges very often say silly things. In the Bold case, they said something very silly. They said it's a margin of appreciation, but if you look at it critically, it's got nothing to do with it. I would agree with you that in the Tokayeva case, as you quite correctly said, they didn't even mention the margin of appreciation, but they allowed a certain latitude to the authorities in deciding. And you mentioned in your thing in the other case, in the Finnegan case, they do say a silly thing. They say in this kind of case, we are going to relax the absolute necessity. Okay, they didn't have to say that. What they were saying is that it's not, that I'll come to, it's not that easy for us to decide what is absolutely necessary in this kind of case. And so we're not going to be so strict in looking at it because we're landing in hindsight. And then I come to the next point, which in my mind is quite, how do I get this down?
Just click it, go to the next page. Just get it to the slides.
There's more here to come.
Did you put it on the slides?
It's just,
Okay.
Is it there?
There you go.
okay. So then you have, my big problem is that the question of judging in hindsight. And it is especially relevant in the kind of cases that you're discussing in this situation. You've got a concrete situation. The authorities have to react, and they have to react quickly. And in both cases, there was a reasonable fear that if they didn't act quickly, the victims would not survive. In the one case, they were executing some of them, or at least they had reasonable grounds to believe that they were executing them one by one. In the other case, they were deprived of water, they were deprived of food. They had to act very, very fast. And so in these kind of cases, it's very easy after the event to come and say you should have acted differently, and we're going to lay down standards. But, you know, if I'm asking in an advice where I'm going to lay down a law, that's fine. But I'm judging in advance, and I'm deciding whether a state is going to be liable. And in that basis, I'm also laying down standards for the future. I can't only be future-oriented. I have to look to the kind of concrete circumstances in which states operate. Why am I thinking of this? Because also much of my work has been international humanitarian law. I was discussing with Manu at lunchtime the question of proportionality. That is exactly the issue. The question of proportionality in international humanitarian law is what I should have anticipated. But of course, after the event, suddenly a lot of civilians are killed. Well, people immediately are going to say you should have anticipated it. And here you have very, very interesting research, which is not based on legal research, but it's based on two economist psychologists, Tversky and Kahneman received the Nobel Prize for economics for this. Tversky died before, and so he couldn't do it. And what did they show? And this is very interesting. You ask people now, what is their prediction of the foreseeability of a certain event? I would say as follows. Chas Shalom, as we say, God forbid, what is the probability of there being a war now between Israel and Syria? Ask all the people in this room, and let us say everybody will say a 5% chance. And then unfortunately, there is a war between Syria. And you later come back and ask the people, now, what did you think? What possibility was there of a war? And they will all say that we thought it was 50%, 60%, 70%. So in other words, the way that you see in hindsight foreseeability is determined by what actually happened. You never see what didn't happen. You only see what happened. And so you think that it was foreseeable. We don't know how many places there were in Bestland where they didn't attack. We don't know how many places there were that they could have defended. I don't know about that. So it is very, very difficult to judge these things in hindsight. And that is exactly why the court is saying, well, there's concrete circumstances. We've got to allow a certain amount of deference for the authorities. We're not there. And so I would say that I don't see so much difference between the way these cases were decided. It is true that in the McConnell case, they said we've got to take a very strict view of absolute necessity. But let's face it, what was the McConnell case? They had information in advance that these three people were going to come into Gibraltar. They followed them from the border. They could track the whole thing. And they had plenty of time to plan. And so in that situation, they said, well, if you didn't plan operations so that you would be able to end the situation without killing people, you obviously didn't, the force wasn't absolutely necessary. What's that got to do with suddenly a situation that I'm suddenly faced with hostages and I have to react immediately? I didn't have time to plan. States are not machines. They're people. And people screw up. And screwing up doesn't mean to say that I'm violating the human rights obligations. The Bestland school case, the UK underground case, which you cite as well. Once again, a case. You had the 7th of July. You had all these bombs on buses and the underground. Everybody's in the state of absolute thing, and they see this guy running, and so they run after him. They honestly believe the guy is jumping over the thing that he must be some kind of terrorist. They're not going to allow another bomb to go off under the underground. So they shoot him. Well, in hindsight, of course, we could say they shouldn't have done that. They should have done something else. But if the bomb would have gone off, then they would have said, no, why didn't you plan to protect the public against this? So you replaced in a vacuum. Okay. Now, the last point is political decisions affecting rights. And the convention does not and cannot provide an answer. For instance, I'm very interested to read your work on the hostage situation. But you mentioned it, that the court has said at various stages, well, this is a political decision. And you mentioned quite clearly in the two cases that there were no negotiations. In the one case, there was negotiations, but not with the people of the highest level. Okay, it was with local. But the very question of whether a state must or should negotiate with terrorists who take hostages is such a difficult question that there is no answer, and that is a political decision. A state can reasonably say, in order to protect the life of future hostages, and in order to make quite clear to terrorists, they are never going to get anything out of us by taking hostages. We are not going to negotiate. Now, I don't think that the European Convention takes a view on whether a state can say that or not. And to be quite honest, even if the Convention takes a view, I don't trust the judges on the court to make that assessment any more than I trust governments to make it. I don't trust governments, but I don't trust the judges more. Perhaps I have the advantage. I sat on one of these bodies. I know who the people are. They're also people. They don't have some kind of extra kind of knowledge and extra wisdom that others don't have. The last people that I would like to make these kind of decisions would be judges who sit there totally removed without any political responsibility. So when they say that, yes, it was reasonable for the Russians and they had a law which said you could have negotiations, you can't negotiate release, you can't negotiate anything like that, well, okay, perhaps I would decide on a different policy. There's no way that I could say that human rights demands the other thing because I don't even know what the results are going to be. Perhaps I'm going to be saving much more lives by not negotiating with any terrorists, and so they know that they're not going to gain anything and I'll stop terrorism. I don't know. That's an empirical question. It's not a question that you want. Okay. Let me just say the last kind of thing, and the national security and the right to life. You've written, it's very nice what you've written on human security. I think you should place that more in the central of your argument. I think you should place it up front, that this is the fundamental issue. I think that we don't talk in terms of that. But to be quite honest, we're looking at the cases that you've given. I don't think that those are national security cases. I think that pure right to life of one person against the right to life of another, every single one of those cases. And as I said, if you're saying that the right to life demands that a state takes action to protect me from terrorism, then you cannot say that when I take counter-terrorist acts for national security, the things don't go together. That's
Thank you. Can I respond now, please? I have lots of response. Right, thank you. With reference to the Human Rights Committee, if I'm allowed to say, there is an article written by Dominic McGoldrick. It was published in ICQ, and he's so strongly in favor of why the Human Rights Committee should use the margin of appreciation.
just let me say one other word on it, why they shouldn't.
Oh, I agree that they should.
No, and I'll tell you why. I think the European Court should have until 1990. I'm not sure they should today. But the Human Rights Committee couldn't. And the reason is as follows. When they first adopted it, as I said, they were dealing with democratic countries in which the margin of appreciation was not going to be great. This was going to be between Great Britain on the one hand and Austria on the other hand. In the Human Rights Committee, you're talking about Great Britain and Denmark on the one hand and the most conservative countries in the world on the other hand. If you have a margin of appreciation that's going to be like this, that is the reason why you can't have it.
Yes, and yeah. In terms of the first, the example, the passage he used to discuss the margin of appreciation, there is a reference to derogation, there is a reference to the life of the nation. In relation to derogation, Article 2 is not supposed to be a derogable right. So
Can I get to the second? It's absolutely necessary.
And my trouble is with this life of the nation term. It's being used here and there, but personally, I don't understand what the life of the nation is. I mean, life of the nation should be the life of people of the nation. But if it's not defined, again, my trouble there is how we can balance something, two things when we're not quite sure what they mean. And personally, I do know what the court or what states mean by life of the nation.
No, you've got me wrong. The court could certainly define what it means by the right to the life of the nation. And I wrote the piece on emergencies in the international encyclopedia of public international law, and I deal with this. Only says the word threatens, and that demands an assessment. Whatever the court decides what the life of the nation means, you still have to decide whether a certain situation threatens the life of the nation. And there, I don't see that the judges have the capability of really deciding this, especially in hindsight, more than within a certain thing. They can decide if it's totally ridiculous, but it's a decision which the decision makers have to make. And it involves assessment.
Can I ask what the life of the nation means to you?
Well, the life of the nation has been defined as being a very, very serious threat. It was in the Greek case. The first case was the Greek case. So it has to actually be something that will undermine the whole structure of society and place the country in a situation which it basically, you've got a kind of vicious circle. That you're placing the country in a situation where it cannot defend its population by normal means of applying the convention. That is fundamentally what it's like. So now there's been this big thing. It just threatens the life of the nation. What happens if it's geographical, if it's only a one point? But it has to be serious. Now it's true. That was the original article written by Gross and Fiona in the island, that the court has shown a great deal of deference on these issues. Perhaps it shouldn't have, perhaps it could have, but you have to have some kind of, you have to have some leeway in deciding what threatens the life of the nation. The court is not capable of doing it. Judges don't have some fantastic kind of mechanism for deciding these questions. They don't. And let's face it, in the McCann case, it was 13 to 12.
Yes, it was
13 to 12.
yeah, but they stick to that for a number
Yeah,
of years.
okay, fine. But the point is that then you have 12 judges on the other court who could totally disagree. So then you're going to say, because one judge decides the case, he's the guy who's going to decide against the views of all.
Yes, but they could have changed it sooner. Could have? No, they could have. Anyway, yeah. The other thing I wanted to say, I mean, about the vote case, I don't have any objections. I mean, I didn't use it as a good example, but I understand why you say that. Okay. Now, what else I want to say? In relation to the lack of negotiations, I think this is going to be very controversial. But one of the problems that we had in the cases was that because the Russian authorities did not negotiate, they essentially had no clue what was happening inside the buildings in both of the cases. I mean, they were not quite sure how many hostage takers there were. They weren't quite sure about the ammunition they had. They weren't quite sure about the intentions. Everything was on the basis, as we said. I mean, there was a feeling that the hostages are at risk, obviously, but they did not have enough information, and that's why they had to act fast, and that's why they used all of this force. Personally, I think that negotiations should be used, if not in the form of consensus. I think that if there was actually some communication between the two of them, they could have reacted in a different way.
So now you're saying you've got to use it once. Because terrorists are not stupid. They're now going to reach your decision, and they're going to say in future when you're negotiating, you're only negotiating in order to get information from us. So why should we negotiate?
But this whole idea that states do not negotiate because in this way they prevent future attacks, etc., it hasn't been very.
Absolutely. The Americans have a policy. They do not negotiate for the release of hostages.
But they do negotiate.
They don't. Not in real time. If
do
they are threatened at the time that they will kill the hostages, they are allowed to kill the hostages. That's American policy.
And they do negotiate through intermediaries. They always do. Even Israel, they say that they don't do, but there have been cases.
Oh, Israel has negotiated the whole time, sure.
So yeah, this whole idea that if we don't negotiate, we prevent future hostage-taking attacks. In my perspective, it's problematic because it hasn't been proved in practice. Because
But you don't know what's the truth that didn't happen. Maybe if they had been negotiating more, there would have been more attacks. You can't say it's not effective.
Not only that, you've got to distinguish, please, between two things. What is your view? And what does the convention demand? There's two different things. The convention doesn't demand everything that we like.
No, I was talking about something completely different. This was something I've discussed on the paper anyway. But if we bring this back to the convention, the lack of negotiation might have a direct impact on the human rights.
Might on both ways.
And then in the case of the Gagebo, for example, the fact that the hostages were in such risk, they did not have water and they did not have food and they did not have access to the toilet, was because the Russians refused negotiating because the Russians kept downplaying the numbers of the hostages.
We don't know. We don't know. We don't. It's counterfactual, Sofia. It is counterfactual. factual. That is our problem. You're assuming that if they had negotiated, the result would have been different. We don't know. That is our problem. We're acting in the state of uncertainty.
So the fact that it was the first day of the school, it was the day of knowledge, and it was the biggest educational facility in the region. And it's a school that accommodates something like 800 students plus fact, and the Russians kept saying in the first couple of days that there were 150 hostages. It wasn't something that they did wrong and had their bearing on.
But that's not about the negotiations. I agree with the court in this case that the Russians didn't take the proper measures that they could have taken to prevent a terrorist attack and to be ready for a terrorist attack, given the specific information that they had about a pending attack on a special day in that circumstance. That I don't take issue with. But that is much more than saying that they should have negotiated. I'm not saying I probably would negotiate. That's not the point. We have to always distinguish between the question of what we think is the best policy. The question is what is demanded by the convention. It's two different things. The fact that I think a policy is good does not mean to say that every state has to agree.
And the convention says that states should act responsibly to protect the right to life, which is not what the Russians did here.
Sure, the Russians, I agree with you. The Russians, I'm not going to have a beef with the Russians.
And my last point, because you mentioned something about how we should protect, there is a question of whether we should endanger the life of some individuals in order to protect the right to life of other individuals, whether they're identified or not, whether we're talking about future attacks, etc., etc. Again, my trouble here is that the right to life is not supposed to be balanced against another right.
You have no choice. Take the German law. The German law that you cannot shoot down the law that said that you could shoot down an airplane. And they said you can't have a law. And now I'm the Minister of Defense. And I'm given very clear information that there is an airplane above and that there's a nuclear weapon on that airplane and that they're going to crash into the middle of Berlin with a nuclear weapon and Berlin will be destroyed. And it's very, very sound information. And I can shoot out of the plane over an area where no people are going to kill them. I'm going to do it.
According to the convention, you're not allowed to do it.
Absolutely, I will do it. I will do it.
Are we talking about the convention?
No, according to the convention, I have to do it. It's absolutely necessary. Nothing there says that absolutely necessary means that I can't endanger the life of others. It is absolutely necessary to save people from unlawful violence. It is absolutely necessary. I have no choice.
If it was a ticking bomb scenario, we had something similar.
Okay, that's torture. That's different. Torture is totally disallowed in any circumstances. But the test is here, what is absolutely necessary. And nothing in the convention says that in taking into account absolutely necessary, provided that I don't kill somebody else. Where is it said? It is I want to save the life of every person in Berlin, and it is absolutely necessary in that case to take this action. No other way.
You want to, or you have to?
I have no choice.
No, but I'm saying I think there's also a dimension of what your obligations are to protect the right to life in those circumstances. That dimension also comes in.
Yes, but that dimension can't be the absolute necessity test. There's no such thing when it comes to positive obligations, because the range of obligations is indefinite.
I have a very practical question. In that circumstance, you have 45 minutes, your plane is on route to Berlin. Do you really consider these obligations under human rights treaties, or do you just do what's necessary?
No, I'm standing next to the guy. I'm standing next to him. I'm standing next to the Minister of Defense. He says, "You're my legal advisor. Tell me on the spot, can I shoot down that plane?" On the spot, I say yes.
And the question is, why do we have, why, if that's going to happen, what is the function of a convention to prevent such thing?
But he's saying the convention allows it.
The convention not only allows it, perhaps the convention demands it, and if I didn't do it, they'd come that I was actually liable for not taking measures to protect the right
Yeah,
to life
I
of
agree.
a million people in Berlin.
In this
That's what I
case,
was just saying,
in this case, you have an obligation to protect and to use force in defense of the right of other people, the right to life of others. In this case, I mean, how can you balance the right with future hostage-taking incidents?
Well,
rather than
that's the problem. You have to do it. As I said, if we now accept, as we must since the nuclear weapons decision, that all actions of the state, even in armed conflict, are bound by the convention, say in that case the covenant, but also by the European Convention. What you're saying is the state can never go to war, even in self-defense. Because when it decides to go to war, it knows that some of its soldiers are going to be killed. So it can't do it. But you're saying you can't do it? Tough luck. Everybody in your country is going to be wiped out. There's nothing you can do to do it, because in order to do so, you have to endanger the life of your soldiers. It's a wonderful theory of human rights. That's human rights. I'm not in
we
the business.
sacrifice the people now so that we protect the future people. Again, isn't it something we cannot measure?
You sometimes have to use tough decisions. The
Is
world
that a
is
policy
complicated
decision or is
place.
that a convention
Yes,
decision?
well, people have to make tough decisions in tough circumstances. Not everything works according to a clear kind of.
So what would you
That's
do
a
with
whole
that
different
aeroplane?
debate.
What would you do with that aeroplane?
I will not answer this question.
I have a question.
As a legal advisor, or as an academic,
As a legal advisor, I would shoot the plane down.
you would,
If I was working for the government.
you would.
You're not working for them. You're together with me, with the legal advisor. We have to take responsibility. Okay? And he's saying, the Minister of Defense, I won't do anything that's illegal. I'm not prepared to do it. You've got 1 second in your order to tell me. This arose in Israel once. 1 second, you've got to tell me. Can I do it or can't do it? And I have to say, not what I think, is it legal? And I'm the same thing. Not only can you do it, you have to.
I have a question for Sofia. So just to go back to your stance that there should have been negotiation. So that is an analysis. If we do a conventional analysis, am I to understand that you're saying that within the responsibilities of the state to respect the right to life of the hostages, there was an obligation to negotiate? Or
I'm not saying that states should be obliged to negotiate. And I'm not saying that the court actually has the expertise to indicate to states how they negotiate
Okay.
or how they don't
Yes.
negotiate. But I do think that when the lack of negotiations have a direct bearing on human rights, that actually the court should remain competent to examine
right.
the impact they had on the right to life.
And so you would reject the statement that it is a political consideration and the court should justiciate that issue.
But in this case, everything
It's a question, it's a question, it's a
everything
question.
was a political consideration. Everything was a
Yeah.
political consideration. Because in the aftermath, the court did not pay much attention to that. But for example, there have been cases, and in both cases, the Russian authorities refused to basically
Mhm.
publicize all the information about the operations because it was national security,
Yeah.
because it was the prestige of Russia in the international arena that could not be undermined in the world against citizens, etc. In that sense, when it comes to terrorism, lots of things are political considerations.
Sure.
And this is why my perspective is that, especially because in the context of terrorism, things get so challenging, and states then deviate from the protection of human rights or can interfere with the protection of human rights in the name of dealing with terrorism and political issues and on-the-spot decisions. That actually the court should remain competent to examine the issues. I don't say that the court should in every case say that states are responsible. And I do say in my paper that actually the court is right that sometimes it says that we cannot impose on states very strict obligations, we cannot impose on them burdens that they cannot deal with. But this doesn't mean that the court should completely step back and say we're not examining these issues.
Thanks.
We're all waiting for you to tell us.
If you're not paying attention.
Norma,
It's just a short sort of case-based question, because I looked at Russia and I'm also looking at Beslan as a sort of game-changing moment for Russian counterterrorism strategy, or at least codified counterterrorism strategy. And if you look at the strategy, one of the things that changed post-Beslan was that the Russians established a command structure that sort of like clarify the relationship between all the different departments engaging in counterterrorism and anti-hostage taking operations, and they enhanced interoperability. How far was, I mean, one of the reasons why Beslan went so wrong is because there's two special counterterrorism units basically. One was practicing the liberation of the school a couple of miles off, so they were like 15, 20 miles off the scene of the school, while the other team decided to storm the school. So basically that was like really poor communication. And how far does that, is that something that's being considered by the court, that there is a duty to actually establish a clear chain of command and to ensure interoperability of your team?
Yes. And one of the things that I want to say that I forgot it is exactly that Russia had the Moscow theater attack, and for the Moscow theater attack, they had the big hostage-taking incident at the hospital in, I don't remember the name of the region. 1999, something like this. So again, the Russians might not have clear obligations when it came to Finogino, but actually they have been very familiar with hostage-taking incidents by the Chechens. So the fact that actually they did not have this structure and this command in place to deal with the attack was one of the main problems. And again, it has to do with states acting responsibly. It doesn't have to do with states being in breach of human rights. It's actually about states taking the right precautions to prevent an attack, or at least to control an attack in a way that will minimize loss of life.
That was fascinating. Both of you were fascinating. I have a number of questions. How has the fact it's terrorism, has that meant that the court has looked at things differently to when it was looking at cases of protecting from ordinary criminal acts? Because it's the same protect the right to life approach. Second question I was really struck in the Tsargayev case. They were referring to ECtHR language, the obligation to take precautions, but then saying you've got to apply the convention. So they were quoting from AP1, but then saying it's got to apply the European Convention on Human Rights. That struck me as very odd. David, I have 3 questions for you. I struggled with the difference between a rule and a standard. You then say that none of these cases we were balancing human security against national security. What's an example of when it was national security?
Well, it would be when the Russians argued, if the Russians would argue that we had to storm the theater because of otherwise our general security would have been endangered, or whether they actually said in one case the prestige of Russia or whatever it happened to be, that's a vision thing, and I agree 100% with Sofia that is not a legitimate consideration. But the court didn't decide it on that basis, because the court said the actual motivation in both cases was saving the life of the hostages. Now, of course, the Russians are high-handed. We know that. The Russians just act like this, and they shoot up, and they do it. On the facts of the case, I have no problem with finding them kind of liable. I have no argument with that whatsoever. I think your analysis of the cases, as I said, was excellent. But don't draw too much on the kind of differences on the case of the doctrine. I don't see that the doctrine is so great. Look, you don't have a clear kind of division between a rule and a standard. The rule is much more defined, and you can really know in every circumstance whether the rule applies or not. The standard is something which is much wider and is not obviously applicable in every kind of circumstance. It does involve in each kind of case some assessment of whether the standard is going to be. If you have the standard of absolute necessity, okay, that is very different from a standard which says that you can't punch a person in the face.
I had one more question for David. The Russians should have never been there in the first place. Wasn't the whole purpose of one of the purposes to bring them, to educate them, to help them along, bring the Russians into the system.
Yeah,
No,
it doesn't seem to work.
And then
50% of the cases in the court are the Russian cases. They pay the compensation and they do nothing else. They don't comply with anything else. They pay compensation. They don't change the law. They don't change the practices. They don't have a culture of human rights. Let's face it, they don't. I'm sorry to say, but it's true. And unless you have some certain basis of it, you've got nothing to do there. They originally, it was a political decision to allow it to trade.
And finally, a very selfish question. I'm looking at proportionality, as David said, and one of the questions is the incidental harm that should have been reasonably foreseeable at the time of the attack. And I think it's a separate paper, a separate conversation. What should have been known? The information we should expect them to have. And I was wondering whether that's presumably something that's been looked at by the court, if not in these cases, in others. What information can we expect a state to have? Can you help me with that?
What information can we expect a state to have?
When taking particular decisions, and I realize it's a step removed from this.
I think if I understand your question right, the court, I think, considered 3 criteria. I think the court said that Russia had enough information advance to know the geographical location, the nature of the attack, and the imminence of the attack.
So they only looked at the information it actually had. There was no discussion of you should be expected to know this. And I don't think it's relevant in these cases. It's far more relevant in the novel formal cases, I think.
I think that's going to be even more complicated to actually expect states to have all of this intelligence information, because it will depend on the capacity and ability of each state to actually have intelligence information. I mean, the UK and Russia might have much more intelligence information than Italy, for example, or Greece, depending on their intelligence operations.
I wouldn't go in quite too closely into the way the Russians get their information. Not sure the way they get the information is almost totally comparable.
Yes, because this raises a number of other issues. Because all of these intelligence operations, there is a question of the right to privacy and data protection under the EU Charter, etc., etc.
This is just a comment that I think was something that you made me think about, which is, again, you started off with the statement that I think states, or that the jurisprudence often focuses on how states must be cognizant of the human rights of the victim. Yes, terror suspects, but here we're looking at sort of collateral effects of state action on. I mean, in this case, we're talking about human rights obligations to their own subjects that are being falling victim to the excesses of their actions. I think that's a really good point, and sort of shifts the perspective again. So, yeah.
And actually, if I'm allowed to follow up on what David said, in the case of Tagayeva, Russia was not found in breach of their obligation to compensate the victims, because they did compensate the victims, and they compensate them on a very case-by-case approach. They took into account each victim individually, and then they did all the nice things about the community to commemorate the victims, etc., etc. So the court did not have a problem with this, although there was a dissenting view that was like, if you don't have effective investigations and if you have no clue what actually happened to the victims, how can you say that you have effectively compensated them? You asked me something about margin of appreciation, right? About criminals.
Not so much margin of appreciation, just the approach of the court, whether essentially it's a case about protecting the right to life, but in a terrorism context. And I was wondering in what ways it varied to protecting the right to life in an ordinary criminal context.
So it's a very interesting case against Italy, actually, the case of Giuliani, if I say that right, that was about the G8 demonstration.
Yes.
And again, there the court basically said that because the forces there, the Italian police forces, the guy who shoots the guy who went very close to them, it was at the time that the police were resting and they were not prepared for such a reaction, so that the attack was unpredictable, and that's why force was used. And also the court said about the fact that there were 18,000 police officers and agents on the ground, and all of them should have had the right training to deal with very extreme circumstances, etc., etc. So again, they referred to margin of appreciation there. And they said that in this case, we cannot hold the state accountable because of the extreme circumstances of a case.
A good margin of appreciation, David? Yes?
Yeah. Okay, I have a question from both of you. And Because as I understand, margin of application, as Professor Kretzmer has very nicely explained to me, is that the court's decision of a factual scenario where there was certain uncertain factual possibilities were there, and the authorities had to make a decision. It may be executive action or it may be legislative action. If I understood correctly, please correct me. So in that sense, two things that I would like to understand. First is that you said principle, rules and standards are different, and then it's the distinction of that makes a distinction between interpretation and assessment. And margin of appreciation, if I understood you correctly, is basically a question of assessment and not the interpretation. Now, since because I understand Dworkin has written on if I understood you correctly, whether you meant
Absolutely, rules and principles.
Yeah, rules and principles. So he made the distinction that rules means either all or nothing, and if you do not apply a rule where it would have been applicable, that is, rule ceases to exist. Whereas principle, even if it would have been, but you not apply it, it continues to exist. So was that the standard that you're talking about?
I'm not using the Dworkin, the more the heart kind of thing on the original work on the judicial process, and I made the distinction between rules, I think, the standards and policies in that kind of thing. And that once again, you can't have a clear line exactly when you're talking about, but there are some things that are clearly standards because they cannot define exactly what conduct you're supposed to do. And there's certain things which are clearly rules. Sometimes you can have an argument, are we talking about a rule or are we talking about a standard? And when you're talking about absolute necessity, it's a standard. It can't be, it's not a rule. Because it involves some kind of assessment. And so that is the essential difference of it. And that's why look, as far as the cases go, as I said, I think Sofia did an excellent job in analyzing the cases and showing what the court actually did in those cases. I disagree with her that there was a departure between the two cases. I don't see that. A bit in the rhetoric. In the actual way, the court decided the facts were different, and on the one question of whether they should have taken action in advance or not, I think there was a clear reason to decide in the one case that they had an obligation which they failed, and in the other case, what could they didn't know about it and they couldn't know about it. So I don't think that you can make much of that. So my problem is that the application in concrete circumstances, in hindsight, there you have inherent problems. And my second thing is that I just do not have this great faith in judges as being people who have some kind of extraterritorial or extraterrestrial judgment in their kind of thing. I know they're upset with it, they don't.
Yeah, I like to use my position here as an alien, as a public lawyer, to raise a preliminary question with regard to the scope of the rights of life, right to life. What I mean, it is doubtless a question of an interpretive nature, and I think maybe it seems to me that this is the key question here, and not the margin of appreciation or deference, whatever that incantation means. And as a derivative, the constitutional or supra-constitutional role of the court. The right to life, I mean, has to have right holder, right bearer. And where these are unknown, unidentifiable, it seems like a classic case of public interest, not fundamental right, not a human right. So if we discuss prevention of future attacks, it seems like defense of the realm, like national security. And I don't see how. I mean, maybe because I'm not sufficiently versed in the European Convention, but it seems to me that we don't have in these cases public security or national security versus right to life, or right versus right. But maybe the problem was that the court actually balanced public interest with public interest, like the prevention of future terrorist attacks with the use of force or whatever the Russian did there. So here I beg to differ.
I don't agree with you. You have a problem here. I mean, some of the cases remind me in which they argued that they are not victims, because they could not show that actually the actions of the authorities had affected them. In one of the Russian cases, it was argued, right, that the actual petitioners were not victims. I think it was in the Russian terror case. But you have a problem over here that when you talk about the duty to protect the right to life, if you have to define it to the right of a specific named individual, it becomes meaningless, okay? So that when the Human Rights Committee says that the right to life demands from a state to do everything reasonably possible to reduce infant mortality, well, it's not talking about defined infants who are not going to die. It's talking about protecting the right to life. And when it's saying that it is about to be a communicable disease, a state has to take action to prevent that the disease kind of spreading, and they're protecting the right to life. It's not an interest. So when you're talking
Is it
about
a matter of policy?
it's a matter of policy, but the policy has to be dictated by the right to life. The court, a country can't say, you know what, we don't care about infant mortality. We're not killing the kids, so what do we care? It can't say, you know what, we don't care if people get killed in road accidents. We're not going to have emergency services in our hospitals. That would be incompatible with the right to life. You have to take action to prevent it. And when you're taking action to prevent it in advance, it's always not related. You don't know who the specific right holder is, but it's still the right to life. And that is why I'm saying that in this kind of context, when I'm going to war in order to protect the lives of the people in my country, yes, it's protecting the right to life.
So if we go back to walking, so if it's a matter of policy, it's an aggregation of small, how to say, like small amounts of wrecks of interest.
No, that's not what he means by policy. But remember the example that Dworkin originally gave, is no one shall benefit from his own wrong. You remember that? And he said you have a policy, a principle, if you want to call it. Principle. Okay, then nobody shall benefit from his own wrong. And okay, so a guy goes and murders his rich uncle, and so that he can now be the benefactor and he can get the money. And there's nothing in the law that says he can't. Okay, so that is what you're talking about. You're not talking about policy in the general sense of a country setting policy.
So what is the difference between policy and principle, between policy and rights? And
I'm not talking about policies here in that sense. I'm talking about a country having to set certain policies which have a tremendous influence on the right to life. And that we are not going to get a court to tell them exactly what policy they have to take in order to protect the right to life within certain parameters. And the court is always set in the margin of appreciation subject to European supervision, right? But that is their notion. Always subject to European supervision. That is their kind of thing.
Thank you, Sofia. Thank you, David.